Hi and welcome back to another video on A-Level Law. Today we're going to be talking about the evaluation of negligence. So this goes alongside the other video we've got on YouTube on just the negligence and the main content. So make sure you check that one out first before you look at the evaluation. Now just as a reminder, we're going to look at what negligence is. And remember, under the Blythe definition, it's an act or omission that causes injury or damage, and the test for negligence is a duty of care, breach of duty, and causation. And remember that remoteness of damage, which people often forget at the end. It's really important that you include that as well around the Wagonman case. So in terms of evaluation, we're going to go jump straight into it. These are all points where you really need to develop. So I call them jumping off points because you need to go further with them. It's not just about writing down a couple of sentences. It's about really trying to develop it in as much detail as you can to get those 15 marks for AO3. So we'll start with the first point. This is around duty of care. And you can split this because it depends on whether the essay you get is fully on negligence, or it's just on negligence generally, or whether it's on the specific parts of negligence. So you could get an essay, for instance, just on duty of care. We're not totally sure whether that's true or not yet because we've yet to see one, but we're assuming that's the case at the moment. You could get one on the breach part, and you could get one on the causation and remoteness of damage part, or as I said, it could be on negligence as a whole. So you really need to be prepared with some kind of points for each bit, just in case. So we'll start with the first one, like I said, duty of care, and this is really around the Capari v. Dittman test and how that's evolved out of Donoghue v. Stevenson. And with evaluation, you can paint a story about how that's changed and how the Capari test is perhaps better because it's a more formulaic and structured test, and it's a really simple sort of structure to follow in court, compared to the neighbour principle, which was a very general legal term. It's not it's hard to understand for a layperson, but of course we have moved away from that now into the Capari test, so that's probably a improvement with the law. The Capari test itself, though, is complicated. It talks about terms like foreseeability and reasonable, and of course those are subjective. People are going to have different opinions about whether something's foreseeable or reasonable, which obviously creates uncertainty and inconsistency, but there is of course flexibility with that in terms of they can make different judgments around different situations and things like that. Now, one of the big changes most recently is obviously Robinson, which basically said that you don't have to apply the Capari test if that duty of care has already been established. So you only need to go through the Capari test essentially if it's a novel or new case, which is really big improvement in the law because it saves a lot of court time in the fact that what's the point in arguing that there should be a duty of care established if it's already been established, and everyone in the court knows that the judges are going to say, well, yes, of course, because it's already been established. So, for instance, patient to doctor to patient, or perhaps driver to another driver or pedestrian. Those duties of care have always long been established in law, so it'd be very unusual for the judge to sit, and probably wrong for the judge to sit there and say, well, actually, I don't think there's a duty of care in this situation. So it saves a lot of court time, and that's, again, a huge improvement. But that is, of course, a very recent change, so you need to make sure you put that in and understand that. Second bit is around proximity, and there's no real definition of proximity, and that's the second bit of the Capari test, remember. And it's very difficult to apply. It talks about sort of time, relationship, space, and it's a very sort of ambiguous term about how to, what really is proximate or in proximity. So students often find this really difficult to apply in terms of the AO2, but you can kind of make that point in the AO3 that if it is difficult to apply, and it's difficult to apply in a scenario, like how it obviously is difficult to apply in the courts as well. And obviously we saw that relationship is really important. We saw that in the differences between McLaughlin v. O'Brien and Borehill. In Borehill, remember, she had no relation to the person that was killed or injured, whereas in McLaughlin, she was the mum of the children and the husband who were severely injured. So perhaps relationship plays a really important part there. And you can sort of see why. Obviously, you're far more likely to be emotionally distressed if it's someone you are in a relationship with of some form. So you can see why they probably held that was proximate in that instance. Moving on to fair, just, and reasonable, that's the third part, remember, of the Capari test. So these first three really are focusing on duty of care. And fair, just, and reasonable is a really good thing to talk about in the essay because it's a policy statement, so it's sort of super vague, and that's the point. The point is the judges can really look at it as an overall thing and decide whether they should impose a duty of care or not. Not whether there is one based on the first two, but whether they should or not. And there's lots of things you can talk about here in terms of opening the floodgates, and the judges will be very concerned about that in terms of if they suddenly say there's a duty of care here, is there going to be lots and tons of claims coming in which the courts can't handle, because of course we know they're already backlogged and struggle with hearing civil claims quickly. Loss allocation, they're really focusing on where the money's coming from. So, they're very they're not as keen, let's say, to hold public authorities and things as accountable as perhaps private companies that have insurance, because the public authorities, of course, that money's coming from taxpayer, and that doesn't, that's not ideal. It's a vicious cycle really of where the money's coming from compared to if it's insured. So they're far more likely to find there's a duty of care if that person is insured. So think about driver to pedestrians. The driver is, of course, drivers are always usually, and should be legally, of course, insured. So actually any legal costs and things come out of the insurance usually, so they're very much willing to say that, and be happy with that, rather than perhaps it coming from the taxpayer's purse. It's all about public policy here, about what's best for the public, and is this really a good decision to hold their duty of care? And you can link in utilitarianism there, Bentham's utilitarianism. Remember, he's the man that came up with that theory, and that's about doing the most amount of sort of happiness or good things for the most amount of people. So they really making that judgment within this. But there is problems also. They'll look at whether it encouraged people to be defensive. So in terms of defensive medicine or defensive police, defensive policing was one of the key issues they really looked at in Hill v Chief Constable of West Yorkshire. And really that's why they held that there wasn't a duty of care. It wasn't fair, just and reasonable to impose a duty of care in that case, because the impact it would have on the policing and the actual strategies and the operational side of actually investigating cases. They just said it wouldn't be practical or sensible to do that. So, and as you can see there, just at the last bit, they said prefer to sue insurance. So it links back to the loss allocation part again about where the money's coming from and whether there is therefore fair, just and reasonable to impose a duty. So there's lots you can talk about there. And it's really important that you do make some of those points in as much detail as possible. Moving on to breach now, there is of course no actual definition of what breach means, and that's really because you can breach a duty in so many different circumstances, whether it's driving, whether it's as a professional, whether it's as a child or a learner. There's loads and loads and loads of different standards and different types of breach, so it'd be very difficult to have a general definition, to be fair. So they really talk about this falling below the reasonable standard of the ordinary person or reasonable person in that particular thing, so the reasonable driver, the reasonable doctor, things like that, which really gives them a sort of objective basis to go on. But of course that is difficult because people are going to have different opinions again, and that again can lead to inconsistency, uncertainty, but of course flexibility is the positive there. It's all judicial lawmaking. Of course, there is no statute on this particular bit, so it's all been made by different cases, laying out the different rules, which obviously has problems around separation of powers. So Montesquieu came up with that idea, remember, that doctrine of separation of powers, and parliamentary supremacy, remember, because the parliament should be the ones making the law because they're elected. And there is, of course, evidence problems with proving a breach. You have to be able to obviously demonstrate it as the claimant. Remember, the burden of proof is on the claimant to prove it rather than the defendant. So the claimant has to be able to establish some sort of evidence that they have fallen below that standard. And that can be difficult, particularly in cases like professionals, where other professionals are more willing perhaps to support what that person did. As you can see really in point 5, which is linked directly to professionals, and particularly talking about doctors here. And the case of Bolam allowed a problem of self-regulation, really, because what it meant is if you could get a body of doctors to come along and say, well, actually, we'd have done the same thing as what the person or the doctor did in that instance, they wouldn't, in fact, be guilty. They would say, well, they didn't fall below that standard, so therefore they didn't breach their duty of care. And that essentially allowed a form of self-regulation, doctors to be able to self-regulate what is okay and what is not okay within medicine, which in some ways is okay because of course they're the ones that are trained, but also there's a problem there of sort of people protecting each other and perhaps when they shouldn't, when perhaps that doctor did actually fall below the standard. Belay, though, actually limited that substantially by saying actually not only does the claimant not only does the defendant have to show that the actions were, their substantial body of opinion would support what they did, they also have to show that their actions were logical and defensible. So it adds this sort of extra test here in terms of you really having to prove what you did was right and logical and defensible there, as I said, which in itself is good because it sort of limits that self-regulation of Bolam, and doctors be able to just say, oh, well, it's fine. Other doctors say, I would have done the same thing. But equally, judges don't have medical knowledge. So how can they determine whether what the doctor did was logical and defensible? And that's sort of not very sensible in itself, really, or logical in itself, because doctors don't have that knowledge. Judges don't have that knowledge necessarily. So equally, it just involves a whole nother layer of doctors having to defend themselves. And whilst that's important, if they really are in the wrong, it can encourage a sort of defensive medicine, which again comes up later as a main problem when you look at the money involved in that. Finally, in looking at learners, is it unfair to compare learners to professionals? So, a learner driver, as we saw in Nethership v Western, is expected to be the same standard of a reasonable driver. Now, of course, that's stupid because, of course, they're not going to be by the very fact of being a learner. They're not going to be at the standard of a professional or a competent driver, reasonable driver. But really, the impact is on the victim. It'd be really unfair on the victim to say, oh, sorry, I'm a learner, therefore, if you've disabled that person, for instance, for life, and say, oh, I'm sorry, I'm a learner, I didn't know what I was doing, I'm not very good. It would be, for that person that was disabled to have no means of redress would be really far more unfair than perhaps holding a learner accountable. Of course, when you remember that learners should legally have insurance which would cover any legal costs anyway. So actually, looking back to that fair, just and reasonable bit earlier about sort of loss allocation and where the money's coming from, that's why they're happy perhaps to say that learners have to be judged by the standards of a competent, reasonable professional because of the where the money's coming from perhaps, and also that the impact on that victim. But it is fundamentally unfair though, because you're not clearly that standard for the very reason of being a learner. Looking at 6, the risk factors that the judges will consider when deciding whether or not the defendant has breached the duty of care or not. Obviously, that's really good that they consider a wide range of factors, so that shows a huge range of flexibility there. They look at public benefit, so that's raises issues perhaps of social paternalism in the fact that are the courts sort of deciding what's good and bad for us and whether we should be protected, although in a nutshell that's not actually necessarily a bad thing, but it's whether you should think the role of the state should be to do that. The fact that they consider special characteristics really important, particularly for people with specific disabilities and things. It's really important that that is considered because actually employers and people should be taking extra care of those people. So the key case there, Paris v Stepney, where he was already blind in one eye, it's really good that they said actually you did breach a duty because you should have provided him with goggles, because actually it does encourage employers to think about these things and protect people that are perhaps more vulnerable. It's talking about driving up standards as well. The fact that, by saying, if you look at Latimer, for instance, where they said about health and safety, laying down the sort of sawdust and things, nowadays that might not be okay. But the fact that they did do everything they could to try and make it safe was enough to say they didn't breach their duty. So it's about trying to drive up standards, particularly around health and safety. And that's one of the key things linking to negligence, health and safety rules. Size of the risk they'll consider as well, just to not be ridiculous. So in Bolton v Stone, that ball had been hit out the grounds 3 times in 20 years or something like that. Although, she was fairly injured in this, the chances of it happening were just not really that common. So it's really good they take that common sense approach there, and it's fair. And you can also link that, of course, to public benefit and the fact that they did consider, well, actually, this cricket ground is offering a huge public benefit to the community. So it's really good that the judges do look at these risk factors as well to say whether, they have breached it or not, because it just makes a wider debate there in terms of whether it's fair and sensible, really. In terms of causation, it's really consistent with criminal law, actually, in the fact that they still use the but-for test here and the legal intervening acts sort of tests. So it makes a sort of huge level of consistency. Not that it needs to be, though, of course, because we know that criminal law and civil law are separate areas of law that don't bind each other. So, but it does provide that level of consistency in a way. The but-for test is largely quite simple to understand, although we can see problems in Wiltshire, which is where they couldn't quite tell what the cause of the baby's injury was. So, whether it was a whole array, a multitude of different cases and diseases and things like that, they couldn't really tell which one it was. So therefore it creates difficulties with saying, well, that is the deliberate cause. And that's one of the big problems with medicine, although that is improving with medical technology and knowledge. Intervening acts are difficult to determine in the fact that it can be really difficult if there's multiple actors involved and multiple causes. It can be really difficult to say, well, which one was the intervening act and who therefore should be liable. And that's really just that general debate around causation and it being difficult to prove. So there's not a sort of a smaller point there. Remoteness of damage is the final bit, and people always forget this bit, but it's really important that you do put it in. It's around the Wagamama case. And this is a really vague test, to be fair. It's sort of like a random bit that's just shoved on the end to decide whether it is too remote and therefore they shouldn't be liable. So it is a bit funny. You can apply the whole test and all be successful and get to this point and say, well, actually it's too remote, so therefore negligence case goes out the window completely. So it's a sort of quite important part, actually, that can determine whether you do win or lose the case. But again, it's based around foreseeability, and foreseeability is a very vague and subjective term, so it can create difficulties there, uncertainty and consistency, but again, flexibility. And interestingly, you can also talk about the eggshell skull rule here and similarities to criminal law with a thin skull rule. So again, you've got some consistency there, although it's called a different thing, of course. And talk about whether you think that's fair or not, particularly looking at Smith v. Leachbrain there. Finally, and this is a really, really good point you want to put in, this is a really much more general point about negligence rather than linked specifically to the law or aspects of the law of it. It's really around compensation culture and the concern that negligence claims allow people, or encouraging people to try and put negligence claims in to get money when actually perhaps they shouldn't be entitled to it. There are currently $4 billion in legal costs, so this is specifically to the NHS. So they currently are have spent $4 billion or need to spend $4 billion in legal costs, with a potential $80 billion in potential payout for. So these are medical negligence claims against the NHS, and that's a huge amount of money that the NHS really could be spending on other things. Now, equally, if those cases are legitimate and people have been severely injured or whatever, then of course those people are entitled to money on a basis of equity, so fairness and things like that. But like I said, it's a huge amount of money coming out of a tax-funded cycle, really. So it's a vicious cycle where we're paying this money in to the NHS, but then they're spending on defending cases. And there's a question there of whether we want to limit that or perhaps get rid of it entirely. I don't think we could really get rid of it entirely, but we could perhaps limit it. And there is concerns about it encouraging defensive medicine, so people actually saying, well, I'm not going to do those procedures because I don't want to take the risk. But it actually generally takes the opposite, in the fact that doctors are so worried about being sued that they'll do every test under the sun, when actually most of those tests really aren't required. But they think, well, I'll do it, because if I don't do it and it turns out something was wrong, I could be sued for negligence. So that means that there's far more tests being done, which costs a lot more money, of course, and that of course leads to huge increases in waits for these tests, because lots of people are having these tests that don't really actually need them. So that could be a result of some of the delays we see in the NHS. Equally, there's low recruitment in a lot of high-risk areas. So a lot of areas such as obstetricians and things like that, so working with delivering babies and things where there's lots of high risk in terms of being sued. They're having problems with recruitment into some of those areas because doctors don't want to take the chance of being sued and losing their job perhaps, or perhaps being criminally prosecuted as well. So they're the sort of main points, and again, like I said, they break down into the different sort of key parts around duty, breach, and causation and remoteness of damage. So it's just worth mentioning some bits on scenario here. So obviously, when you're writing a scenario on negligence, make sure you start with the AO1. Always begin with the Blythe definition of negligence. People often forget that. They go straight into what the test is, but they forget to actually define what negligence is. So remember, an act or omission that causes damage or injury. Make sure you lay out the core parts, and like I said earlier, don't forget remoteness of damage, because that's a classic thing that people always forget in the wagon mount. It's really important you get that in, because you will get a mark on the mark scheme for that, and most likely. And make sure you apply each part methodically. So remember to use Caparo or Robinson depending on the facts, and that's a big new part. So it's really important that you do understand when to use Caparo and when to apply Robinson, and make sure you go through it really methodically, saying, for breach, for instance, whether it's a professional, whether it's a child, and make sure you omit the relevant details as well. So make sure you don't put stuff in that's not relevant. So if there's no children involved, there's no point talking about that as part of breach. Equally with professionals, you don't mention it if it's not relevant. So it's really about picking out the key parts that are relevant to the scenario. Make sure you also consider any potential defences. So the two key things really you're looking for there are contributory negligence or valenti, and the question should specifically ask you, hopefully, if that's what they want you to do. So just make sure you consider that as well. And as I said, the essay could focus on the whole of negligence or just one aspect. So be prepared to have a look at that and really make sure you read the question first to determine what's being asked for. Because, for instance, if it was just breach or just duty, for instance, and you start talking about the other areas, you potentially get no credit for those. So it's really important that you understand the question before you start writing it. Thank you very much. I hope you enjoyed that. Please subscribe to us on YouTube and join us on Instagram at Law at Portsmouth College. And there'll be more videos on the rest of the talk coming up this week. Thank you very much.